Good evening, everyone. Good evening. Good evening. Woo! It's a beautiful Friday evening. Yeah, it could be night there in your location. Whatever it is, I'll say good evening to you. Wow, how do you want to spend your weekend? Hmm. Should I be the first to wish you a happy weekend? Wow, it's a great privilege to have you in my platform to view this webinar this evening. Thank you for coming. Thank you so much. Thank you. Without you, I can't be here. Even if I'm here, I will just be speaking it to the here. No, I don't want that. So I cherish you for coming. Thank you so much. Wow, this is Family Robust, where we believe family robust is a reality. Is a reality, no matter what. Family robust is a reality. And this webinar this month is focusing on family and law. Family and law. You know, it's a beautiful thing when we know about family, when we know about what can cause the family not to have a robust, you know, that's why, and there's no ignorance in law. So we had to bring our learned people into the studio, and guess what? They are very much ready. Oh, I'm Janet Ajobie, where I'm a family coach. I'm a rescue agent on a global mission. I go with full force wherever I need to go, ready to work everywhere. Yeah, that's the spirit. So thank you for coming again and again and again. I will say thank you 1,000,000 times if I need to say it. So our barista is in the house now. Barista Rotimi is here. I would like to bring him up. Barista Rotimi Ajobie is a very wonderful person. You know, the baristas I'm bringing in today, it's not that they are just called to bar. No, they have good experience, very good experience, wonderful experience. And you know what? I'm so proud of them. These are my brothers-in-law. They are even one of the reasons why I have an authority to speak about family. You know, when it's time for me to talk about in-laws, I have a beautiful experience about in-laws. So I can teach on how to get and how to live pleasantly with your in-laws. Don't mind me. You might wonder why I'm laughing. My husband is proud of that. And I just had to laugh about that. But sincerely speaking, they are my brothers-in-law. We are Ajobieways together. So is it not a privilege to have the laws in my family? Thank you so much. Let me bring in Barrister Rotimi Ajobiewe. Please, drum rolls for him. Drum rolls as I'm bringing him in. His network just kicked him out now, but he will be back again. Before we'll continue, before he'll be in again, let me say something about him. Wow, he is so proud of his day that he was born. He told me he was born on August 3rd to the family of Ajobie, where he's married with a child, practicing law in Nigeria with vast experience for more than a decade. Yeah, more than a decade. He's back. Let me please give a drum roll for my brother-in-law, for the learned person in the house today. Barrister Rotimi is here. Thank you. Good evening, sir. Good evening, sir. Thank you for coming. Thank you. Can you hear me? Can you hear me, sir?
Hello.
Hello. Yeah, good
Yeah,
evening, sir.
yeah. Good evening. Thank you for having me. It's a pleasure to be part of your program tonight. I'm sure everyone will
I'm
be blessed
grateful.
as well.
Thank
My side.
you. Thank
Thank
you
you.
for coming, sir. While we
I
expect
appreciate
Barrister Sheung Ajobiewe, he called me that he's in the studio, so probably because the network is having issues there. But before he comes in, I want you to please start with what should we know about wills and inheritance?
Thank you very much. Um, the key thing we have to bear in mind when it comes to issue of will and inheritance, it has to do with the estate of a person to his beneficiaries. That is very important. Estate of a person to his beneficiaries. The fear that people mostly have around this part of the world is that once we talk about a will, they will be thinking that we are wishing the person death. When you tell somebody, okay, you need to have a will, he will now say, so you're wishing me to die. Um, it is a saying that if you don't plan to succeed, you plan to fail. If you don't have a will, and at the time of your death, there's nothing to show who you're bequeathing your properties to, then be expecting that there'll be chaos after you leave. And whatever legacy you must have built might not stand it. So will, we usually call it that it's a testament. It's a testament. Why do we call it a testament? It's like it speaks after the death of a person. It speaks after the death of the maker of the will. So for a person to make a will, first of all, he has to get a lawyer, and another person must be present for him to make that will. Or at times, it might just be his lawyer, but the most important criteria there is that he must be of a sound mind at the time of making the will. If there's any evidence or proof that at the time of making the will he wasn't of a sound mind, then that will fail because it will be believed that whatever he must have of had written down as his will was made out of a mind that was not seen. Maybe he wasn't well, was motivated by other things, or his judgment was beclouded. So it is very important that at the time of a will, the maker must be of a sound mind. And that's why if you see any will, it must be part of it. It will be stated that I, so person, is making this will and I'm of a sound and good mind.
Okay.
It is very important. Now, the will must contain how the maker wants to bequeath his properties, how the maker wants to bequeath his property to his beneficiaries. If he has like if he has like 10 houses, he will have to state it in the will that okay, I'm bequeathing my first house in Lagos to my first son. I'm bequeathing my house that is in Abuja to my wife. It must be stated clearly without ambiguity. And once the will is made out, the next thing to be done is that it must be deposited, it must be signed by the maker and a witness, which could be his lawyer. Then that will must be deposited in the probate registry of the court. So that at the event of his death, there will be a copy of that will at the probate registry, which the lawyer will read, will apply to read. But if it's not registered, it becomes a problem. Now, it is very important that at the point of making a will, like Nigeria, for example, or even around the world, we are divided into what we call jurisdictions. The way Kano State is different from Lagos State, the way Kaduna is different from Plateau State. That's how we have jurisdictions. So, for example, a maker of a will has a a property in Kano, he has a property in Lagos, he has a property in Jos, Abuja. At the time of making that will, he must deposit a copy of his will in every state where he has or she has, what do you call it, a property. Because that is the mistake most people do, or the lawyers they engage if they are not experienced. They make a mistake by just depositing the will in Lagos and forgetting that the man has properties in Plateau, which must be reflected in the registry, in the probate registry, so that in case of his death, the registry there is aware that this is the will of this man and it covers so property in our state. So it is very important. Now, another issue about a will is that a will, when a person dies without a will, we call it a person dies intestate. That means the person doesn't have a will. That means it is left at the mercy of his beneficiaries, those people living after him. So at that point, it becomes a problem. Now, from where I work, we have seen that experiences that when a man dies, all these rich people, they have 4 wives and they die without having a will. What happens is that the first wife, having knowledge that the man has properties in River State, Port Harcourt, will hurriedly go to Port Harcourt and apply for the registry and for the letters of administration to administer the estate of that man. You understand? So in that situation now, it is like, for example, now 4 wives. The first wife or the whole family had to come and sit down together and agree. Now, if they had been in disarray or they have been fighting, immediately the man dies, the 4th wife might just run to, maybe she's in Enugu, she'll come to Enugu State, apply for the properties of the man in her name. The first wife, maybe she's in River State, she'll go to Port Harcourt, get a letter of administration and put it. And those who don't have the understanding, by the time you check, there will be nothing left. Everybody will be scrambling for what they want to get, and most of the times it ends up in court litigation after litigation. So it is very important for us to have a will. It prevents our family from having chaos and trouble and getting disarrayed after the death of the maker of the will or the owner of the properties. Now, we have to bear in mind that when a person dies, there's what we call contestation of will. If, like, as I said, God forbid it will be a portion like a family, we have seen it, where a man was married to a 1 wife and has 4 children, and the children don't agree among themselves. Despite the fact the father had made a will, there will be contention. Once there's a caveat, we call it a caveat, it's like putting a notice that, okay, this will, we are contesting this will, that what is inside, we don't agree. And we suspect that it wasn't made by our father. We contest it. So in such cases, I've seen situations where siblings are fighting tooth and nail. Not that different mother, the same mother, siblings of the same set of parents, going from one court to other, contesting the will of the man, of the parents, saying that they don't accept. So it's allowed under the law. We call it caveat. A person can enter when there's contention on that will. A caveat will be entered. So that is another angle. So after the will has been gotten, there's a period given for 28 days, or in some jurisdictions 21 days, that anybody who is in contention of that will should indicate. And once that is done, the matter will go to court, and long litigation will start. We have clear example of people in our society who had that problem. People like Abiola, MKO Abiola. There's still problem to today. They are still contending the will of the father. Some set of the children will come and say, no, we are not accepting it. They are still in court. Chief F.R.A. Williams, a very, very popular, renowned lawyer, the same thing. Some of his properties have been, yes. So it is very important we do that. And although it doesn't relate, it is very important also as parents when we are growing up to make sure that there shouldn't be division among our children, because that's when some of these arise. If a parent is able to grow or groom his children so that they love each other, so that knowing that whatever is the outcome of the will of their father, they should take it in good faith. It is very important. Now, we come to the issue of inheritance is somehow intertwined and interlinked with marriage. Why do I say so? We have seen in Africa, Nigeria, for example, that when a person dies, you see sometimes the relatives to come and rush the inheritance, the properties he leaves behind. This one will say, I'm his brother, so I'm entitled to carry all the properties. And that one will say, no, I am his father, so I should carry all the things. So, so we have seen that in numerous times. We have seen it. So why am I saying it's connected to marriage? For marriages made under the law, that means marriage made under the law, it is settled in such cases that once a marriage is done under the law, we know it as, what do you call it? Marriage under the law, that means marriage under the act. Church wedding, some people call it. But we have to be careful that it's not all churches or all church weddings are known as marriage under the act. We have to understand that a church must be registered to be able to conduct or is licensed to conduct a marriage under the act. So if you go to any kind of church, we think because it's a church and they give a person a certificate after the wedding, that means the marriage is a church marriage or marriage under the act. You are mistaken. Under the law, in such a case, if the church is not a licensed place of worship to conduct marriage, such a such a church, such a marriage, that's why you're giving a certificate, is considered under the law as traditional marriage. That is the classification of that wedding. But if it's a marriage under the act,
is in the house. Barrister Sean is in the house. You're welcome, sir. Thank you. Thank you for coming. So let's give a drum roll as he comes. Woo! Let me bring him in also, sir. Wow, you're welcome, sir. God bless you. Thanks for coming.
I can apologize for coming on late.
You. No problem. You communicated earlier that it's the network issue, so there's no problem, sir. Thank you so much. Thanks for coming. Barrister Rotimi has been talking to us about will. He's been talking to us about inheritance. So if you have anything, I would want him to finish the point at which he's saying right now so that you can also contribute. Then questions are already coming so that we can ask you. And I want to tell all our people, please, if you are watching, you have any question, please send in your questions so that I can document them and ask our barristers. Thank you so much, sir. God bless you. Please go ahead, Barrister Rotimi.
Yes, as I was saying, so if a marriage is conducted as marriage under the act, at the time of the death of the man, the wife automatically becomes the inheritor of the property, whether there's a will or not. Because under the act, it is seen as the wife and the man are one, and immediately after his death, she succeeds him. So where there's even no will, the property goes back to the wife. That is the position of the law. It goes back to the wife. But we have seen in where the marriage is not done under the act, it's just a traditional wedding, then we will have to contend with the tradition or the custom of the people there. So if the custom says that, okay, at the death of the man, the property will return back to his brothers or to his mother, then we know what will happen. So that is very important. That's why I'm saying inheritance is also tied to the kind of wedding or marriage done. So if it's a marriage done under the act, it protects the family against in the event of the death of the man, the properties or his inheritance stays within the family if there's no will. But if there's a will, then the will will supersede. Thank you.
Thank you so much. God bless you. I'm getting so many things that I've never had in my life. Thank you for this expository talk. Wow. Tradition. Okay. I'll tell my husband we have to sit down tonight and write will. So it's very important. Whether you're a pastor, whether it's anybody, everybody has to, if you are listening to me, have to make this decision. He's not going to die. No, you have heard a barrister what he said. It's just for orderliness. It will even show that you are a orderly person when you have prepared. Wow, thank you so much, sir, Barrister Rotimi. Barrister Sheon, can we have you, sir? Wills and inheritance. What do you have to tell us? What do you have to teach us this night?
Thank you
Thank
very
you, sir.
much. Thank you very much. In addition to what Barrister Rotimi said, the type of marriage you conduct has an effect on inheritance. Now, to further add to what he said, assuming a couple should conduct a marriage under the Act, which is either in a marriage registry or in a church that is registered to conduct weddings, such a wedding is a marriage under the Act. Now, however, if the husband should die without a will, yes, the wife stands to inherit, but however, under the administration of estate laws, it is not just the wife that will inherit, because under the administration of estate laws, if his wife is alive, the children, they will have a certain percentage of his estate. When we mean estate, we mean the properties, personal or
Real.
assets. Now, like I was saying, the wife will have a certain percentage, the children will have a certain percentage. If any of his parents are alive, they stand to get a certain percentage. It's depending on what the administration of estate law of that state where he's resident states. That's one. Two, if he doesn't conduct a marriage under the Act, that, as we call it, a church wedding, it will be left for the tradition and customs of that place. But however, if the family is fast, which means he died interstate without a will, which means the family have one or two or three options open to them. That's what we call letters of administration. A family can go to the probate courts within that state and apply for the letters of administration, stating that they are the wife and children of the deceased. Which means once the letter of administration is given, now in that letter of administration, the assets, whether it's real property, the money he has in the bank, anything that is of value to him, even the houses, all those items will be listed in the letters of administration. And then the chief judge of that state will give out a letter of administration stating that these are the people that are going to inherit the estate of the deceased. But however, they are going to pay a certain percentage to government. Now that's one of those ways. Now, but it's advisable because, like I said, the administration of estate law will determine who will get what: the wife, the children, the surviving siblings. It is advisable that either a man or a woman, because even if a woman dies, her husband too, if she is married under the Act, her husband too can inherit. If there's no will, the administration of estate law will come into place. He will inherit a certain portion of her assets. The children, the wife's siblings, or her parents to have a portion. But however, it's neater for couples in their lifetime to do a will, so that you can state explicitly whether you just want your wife and your children to inherit and cutting out every other members of your family. Now, In making a will, you need to get your lawyer to write your wishes and aspirations on how you want your assets to be shared between your beneficiaries. Now, in doing that, you can decide to give your children, your wife, whatever you want. Even if you have maybe a relative that you feel is not being taken care of, you could put a clause in the will for that person to be catered for. Now, however, in making a will, you must be of sound mind, which means you are not mentally deranged, you are not sick, and then there's no influence of fraud, which means you did it with your sound mind without no external influence. Now, one of the cardinal rules of making a will is that beneficiaries of that will, that's those people that stand to benefit from that will, they will not act as witnesses, and they are not expected to see the will at the lifetime of the person making the will. So when the lawyer makes the will, when the person reads it, he must have at least two witnesses present who must sign as witnesses to ensure that the will is binding. Once that is done, the lawyer will seal it and deposit it at the appropriate registry of the High Court of that state. So that in the event when the man or the woman should die, the lawyer will now write to the probate registry informing them that the maker of that will is late, and a date will be set for the reading of the will. Now, basically, that's how a will is being made. Now, when you make a will, you cannot, once it is signed and deposited, you cannot amend or change anything. The only way you can do that is by making a codicil. Now, a codicil can either a codicil. Now, you can only use a codicil to amend what you've written in your will. Let's say maybe you just brought a new estate, a new house, which was not contained in the former will. You will now do a codicil saying that, oh, as of so date, I've made a so will which is binding, but as of that date, I have not yet purchased this property or this asset or these shares. So I now bequeath these shares to either my wife, my children. Now, in making that codicil, there must be two witnesses there who must sign it to make it legally binding. Now, you can also use that codicil to maybe alter your will, modify it or amend it. Maybe one of your sons insulted you and you inherited him. And you say, oh, do you think because I've added you to a will? You can now do a codicil and say, oh, that's my stubborn son. I've disinherited him. You shall no longer inherit from that will. Now, you can also use a codicil to even vitiate the will that you've done. That, Kai, my children have suffered me so much. I have vitiated that will. It's no longer legally binding. So he can now do a new will afresh. So now, a will and a codicil. But however, most times when wills are made, that's what we call a testament, which means your deeds are speaking after your death. That's what Jesus Christ did. His testament. That's why we call it the New Testament. The deeds, the acts of Jesus Christ. Now, a will is also a testament of a dead person. Now, in many instances, when wills are made, the family tend to say, oh, my father did not give me what I wanted. My mother did not give me what I wanted. And you now see them going to court from one lawsuit to the other. There was a very popular man in Rivers State. He died for a number of years. Before they could bury him, it took years because the wives went to court, the children went to court. Those that wanted to inherit the properties were saying that the father didn't do it under a sound mind. He was ill when he made that will. Now, in the process, he had given some of the children some of his properties during his lifetime. So, but they were not satisfied with it. They decided to challenge that will in court. Now, another way of, settling your inheritance is what we call deed of gift. In your lifetime, you'll do a deed stating that this my property in so city, in that city, I give it to my wife, I give it to my children, so that in your lifetime, your family will know what you've given to a particular set of person, so that even when you die, there won't be issue of, oh, my father did not say this, my father did not say that. So it will
But
bring
do
to an
we need
end.
that? Do we need to make it known to everybody if it's a gift?
Yes, that's why it's called a deed of gifts, which means in your lifetime, you are giving a certain person a certain gift from your assets, so that you can even share all your properties before you die through the deed of gift. You can even make provisions for your burial, for everything through that deed of gift. So that when you die, nobody will go and challenge the will, because you won't make a will if you want to. So there are different ways of settling your estate and your affairs, either while alive through a deed of gift, or when you are dead through a testament called the will, the codicil. So that's basically a little
Wow.
about inheritance.
Thank you. This thing is so, in fact, it's giving me an unbalanced seat now. This thing is just so expository to me. Many things I thought I know, I didn't know. Oh God. Thank you for teaching us from the depth of your heart. See, that there are a lot of, oh God, there are a lot of questions coming. Somebody has, if a will is done in UK, will it be acceptable in Nigeria? Barrister Rotimi, please, can you answer that?
Yeah, it will be. The key thing there is that now, as he said earlier on, where the properties or whatever the beneficiaries will get, where it is situated. If like the properties we are talking about, the a will was made in UK, but the properties are situated in Lagos, Nigeria, then yes, they have to bring that will and deposit it at the registry of the High Court of Lagos. That's why the fact it was made in UK, but it must be deposited in the registry of the High Court of Lagos State, because that's where the properties are situated. So it is acceptable.
Okay. What about
Can be
if
done.
the property is in UK and the will is done in Nigeria? How do we do it?
It's the same thing. It has to be taken
Okay.
to that jurisdiction. It must be
Okay.
deposited there.
Okay. Okay. Thank you, sir. Somebody asked again, he said, is there a price fixed for will making? Also, is there an age limit or property limit that needs to be attained before considering will?
Well, basically, once you're of a sound mind, that's of age, 18 years in some jurisdictions, 21 years, which means you have the legal capacity to enter into a contract, which means you are now an adult. When minors do make wills, basically, what do they even have as assets that they want to give out? So basically, under the law, you must be of an age making, you must be of the age to be able to enter into a contract for you to be able to make a will. You understand? So that the will will be legally binding. What was the other question that you asked? I forgot.
The microphone is off.
Oh, sorry. Is there a price fixed for will making?
Okay. Basically in the legal profession, the industry you put into creating of a will, the time and the assets base of that client will determine what you charge. All fingers are not equal. So it depends on the asset base of the client that will determine what the lawyer will charge. Because basically, in the legal profession, we have what we call bill of charges. For you to do your bill of charges, if it will take you maybe 10 hours, a month or 2 months to collect the whole properties, to verify the authenticity and location of those properties, which means you put in so much time, so much industry. It will not be the same thing with someone that maybe has just a one-bedroom bungalow that you can see, you know. So it takes the industry of the lawyer that will determine what the lawyer. There's no fixed price for it.
Thank you. There is another. He said, are there any restrictions on making wills? Cultural restrictions, e.g. Please, as you
Well,
I'm just throwing the question. Anybody can
okay.
answer, please.
Well, basically, a will supersedes cultures and tradition. The will that you make means it's legally binding on your family members, it's legally binding on the general public as it concerns you, which means once it's registered and deposited at the probate office of a court, it is that court that will even help in enforcing the will, which means it supersedes culture and tradition. It's whereby there's no will, there's no deed of gift, and the party and the couples or the husband is not married under the marriage act. That's when the laws, customs, and tradition of where he is from will come into play. So, but once you have the will, the codicil, the deed of gift, or married under the act, the cultures and tradition of that place will not come into play or into play. Thank you.
Okay. Another question says, can any lawyer be choosing to become your personal representative? Barotimi, please.
I don't understand the question. Choosing a representative like a lawyer to make the will or as a witness?
Please discuss both because it's a question that came in.
Now, it's going to be very important that as a lawyer who is drafting the will, that you shouldn't be one of the witnesses. You should get two different witnesses to witness that will. It is very important. What do you call it? Ethically, it's not proper. You're the lawyer making the will and you're also being the witness there.
And the lawyer must not be a beneficiary.
It's not proper for the, yes.
Must not be a beneficiary of the will.
Yes, it must not be a beneficiary of the will. So the witnesses should not be beneficiaries of the will. Two independent witnesses to witness it, but as to representation.
The only time that a lawyer can be a beneficiary of the will is when his fees is in a future time for the execution of the will. It will be stated there that during the reading of this will, which is the execution of the will, my lawyer should be paid so amount or so percentage from my estate. That's the only time that a lawyer can be a beneficiary based on his fees for the execution of that will. Thank you.
Somebody said, my properties are not listed in the will. Would this be an issue?
Well, like I said earlier on, basically, if the properties are not listed, let's say, assuming he or she has maybe like 5 or 10 properties, and he or she intends to bequeath it, which is give it out to different persons, and that person has stated that he's giving them out without listing them, it's not legally binding. The person must state emphatically, my property in Ekiti, I'm giving it to so person. My property at so number in Aja, I'm giving it to so person. So that there won't be issues of, oh, this person has like 3 properties, so which one is he talking about? It must emphatically be stated in the will to make it legally binding.
Thank you, sir. Another question. Okay, he said, what of institutions where parents give their properties to an underage child before their death? Can the underage child claim the inheritance?
That means they can give that child as a deed of gift they can bequeath it to that child. But if at the time of their death and the child is still a minor, then the child will need what do you call it? The child will have to wait till when he becomes what do you call it?
Of age.
A of age before he can have access. That's why we have seen many cases when, like even in kingdoms, that they will say that a person is a regent, holding the kingdom or holding the properties, pending when the child will become of age. A very good example when Paul will be talking that that a child in the law is nothing until when he becomes of age. So it's the same thing. So where the parent may have bequeathed the property to the child, but the child is yet not yet of age, then somebody will have to administer the property on his behalf until when the child is of age, then have full rights. But if the parents during their lifetime can give the child a property to a child, then through a deed of gift, they can automatically just hand it over to the child.
Now, in addition to that, there's what we call trusts. A trust can
Yes,
be
that's the
created,
trust.
like in terms of funds, that when the child is of age, maybe 21 years, 30 years, 40 years, the child will be able to, take control of it. Now, there's what we call a legal guardian. A legal guardian can be appointed to hold those properties in trust, just like Barrister Rotimi has stated, in trust for that child until it's of a certain age. Now, clauses will be put in place that the legal guardian cannot sell those properties until that child is of age, so that the legal guardian will not play a fast one on the child. So there are clauses to safeguard the interest of the child. Thank you.
Thank you so much. I know very well that my people will follow after you after this this program, because the way the questions are coming up, flowing in, so many people that are not even online will want to ask questions later. But I am sure that you will be so kind to answer the questions even after this live event. Another question, sir, and says, what are the things to consider when choosing a lawyer to act as a personal representative?
I think Pastor Sean should answer that question.
Well, basically, there's no hard and fast rule in choosing a lawyer. The thing is, what you look out for is the integrity of the lawyer. One, two, the experience base of the lawyer in terms of practice and his compatibility. That's his competence, the competence of the lawyer in handling diverse matters for the client. That will go a long way, because we've had instances whereby lawyers have put a lot of people in trouble. One, because they are inexperienced. Two, dishonest. And three, fraudulent. Maybe Barrister Roti will be able to tell us more about those kind of fraudulent lawyers, because they deal with those kind of lawyers every day in the line of their duty.
The thing is that that is true. It is very important because at times, at the time when the will be read, the the maker of the will have been dead. That's why we call it a testament. So he won't be there. So that's why it is essential you have a lawyer that you can trust, that has integrity. Many times the lawyer will connect. That's why as I was stating earlier on, that like in an extended family or even a family, there's a nuclear, but there's division in it. One faction in the family will buy the lawyer, and the lawyer will tamper with the will. So it is very important we have a lawyer that has integrity. Many times we have seen institution, the line of our job, a lawyer that was engaged by the maker of the will to do it. But we now discover either there was a forgery or there's something else done that compromised the will, that brings the possibility that even the maker of the will was not the one who made that will, or the codicil that followed. There was a codicil that followed, um, vitiated the will, and highly suspicious that it was the lawyer who connive with a certain faction of the family to tamper with the will to benefit those people, whether they give him money or favors. So it is very important we have that kind of, you have a lawyer that you trust very well to be able to handle such things. Thank you.
It is well. God help us, because now this particular question now is, even to me, if not that I trust what you are saying now, that means we still have lawyers that can still, I don't want to say do, because why can't we trust the lawyers? As in, now that I said my husband we must do our will today. How do we now say these are the ones we trust? What are the things that you can just advise us to look for in a lawyer? Is it how old they've been practicing or what, please, sir?
It has lots to do with how old the person has been practicing. It is from little things we give them to do for us, be able to start gauging the level of trust we have in them. Through little things, little things you're giving the person, whether the person has the integrity. That's a test. Little things before you give the person bigger things to do. Over time, be able to gauge the integrity of the person, whether you can go along with that person. Secondly, as Pastor Shim stated earlier on, that the experience of the lawyer. Sometimes the lawyer may do mistakes which genuinely he's doing it because of lack of exposure and experience, lack of competence. We have examples like where a family, very rich person, example in Port Harcourt, Enugu, anywhere, has a lot of properties and he has companies. And when the man now dies, the company has shareholdings. Then now you, the lawyer, will come and say that, okay, that this company should be inherited by the first son, which is not possible. The company already has a shareholding structure. The father who owns the company, who has like 50% of shares, it is his shares there that is now liable to be shared among the family or to the first child, depending on the letter of administration or the will. And if like the wife or the daughter there already has her 20% stake in the company, the lawyer cannot advise that, okay, because the first son is a male, he should now take over the whole company, not minding the fact that there's the daughter who already has 20%, the wife has 30%, and part of the 50% shares of the husband, who is now late, is to be divided among the wife, the daughter, and the son in 20% capacity. 20-10 capacity. That means there's no how the son can become the overwhelming shareholder of the company to even take over the whole company. So exposure and experience of the lawyer matters. Integrity, by giving him small things to do and watch the outcome, will also help. Thank you.
I'm blessed to have you, sir. I'm blessed. Wow, is the time flying? Jesus. No, we want to be here. We want to stay here and learn from you. I know we can't learn everything, but we just want to talk this night. Yesterday was for land, but somebody came in and dropped a question on land, and we just have to satisfy our audience. Please, I want you to answer this question. It says, Lagos State government is taking over my plots of land for seaport use. Will I be given opportunity to negotiate the compensation amount?
Well, basically, the governor of a state is much or less has an overriding right to acquire the property in the interest of the state for public purposes. Now, if a seaport is going to be created, that means it's for the public. Now, however, when that property is well registered, or assuming that it's owned by a family which is known. Now, the ideal thing is that we have what we call estate valuers. The Lagos State government will value the property for compensation. But however, if the person feels that the value they are calling or they've assessed the property to be is far below the value that they think their property is, because basically land after the Land Use Act belongs to government. Now, if government is taking it over, they can only pay for, cash crops and other developments on the property. But if it's just a bare land that has no economic crops or anything, the government may now take into consideration the value of properties within that vicinity. So if the person feels, however, that the value of what the property has been assessed by the Lagos State government is not sufficient, that's what we call the Land Use Allocation Committee. That person could write to the Land Use Allocation Committee of Lagos State, telling them that the value of the property has been undervalued. And then if the Land Use Allocation Committee of Lagos State are not forthcoming with a positive result, that person can still approach the Lagos State High Court, which has the jurisdiction to entertain such matters, for the court to decide whether or not the compensation being given is fair or not, having taken into consideration the value of the property or the development of the property or the value of properties within the vicinity. Thank you. Sorry, your mic is switched off.
Again, I'm sorry, I'm trying to prevent interference of sounds. That's why I kept muting it. So now, my viewers, as I was saying, please keep dropping your messages, your questions.
Hello, Barrister Roti, what's happening?
Sheila, you're still on air. No,
I think it's a network issue.
The network is quite bad.
Okay. Excuse me.
Please, I'm very sorry. The light tripped off and all my connections just went.
It's okay. It happened.
So that was a distraction. I'm sorry. I just feel so good, that my people are saying thank you so much for the valuable advice. Wow. Honestly speaking, everybody is enjoying it. Somebody said network, why now? As in, why now? Wow, this is great. Please keep dropping. We might not be able to we might not be able to answer all the questions, but we'll answer. Please, do you have any social media handle that you would want to tell my people, so that in case they want to ask you or get back to you, or they should keep dropping here? How do we assess you, sir?
Barrister Shil.
Sorry, I didn't get what you were saying. Sorry.
Whether you have a handle that
thank you.
They could access.
Hello, sir.
And drop questions.
Hello.
Okay, I can hear you.
Can hear you.
No, I was asking.
Okay.
Andrew, do you mind? If you don't mind,
Sorry.
if it's something personal, private, there's no issue.
Okay.
Beneficial.
They can reach out to me through my email, babashiontheodore@gmail.com. Or they can also reach out to me. Okay, Twitter has been banned in Nigeria, so I would have said they could reach out to me on Twitter, but Twitter has been banned in Nigeria for now.
Baba Shion.
Theodore. They can reach out to me either through
Don't
my
worry,
email,
we'll see.
babashiontheodore@gmail.com.
Please, a question came in now, and I need to address the place of next of kin. Next of kin. Does it mean one
Oh,
somebody just said
sorry.
so person is my?
I actually wanted to. Hello, can you hear me?
Next of
Hello.
And the network.
Okay,
The
I think
network
it's
over
our
there.
network. Can you hear me?
Yes.
I had wanted to give a talk on the issue of the next of kin. It kept my mind. Now, basically, what we call next of kin is an aberration that most people have been using. You know, next of kin means, let's say, maybe if you're working in a government establishment or even in hospitals,
yes,
if an operation procedure is to be carried
yes,
out, they'll ask you who's your next of kin. When they mean next
yes,
of kin, that means who's your closest relative that could be contacted in case of emergency. It has nothing to do with inheritance or, succession. So most people, when they feel that because they've already placed a family member, either their wife, their brother, their sister, or their son as their next of kin, they feel that if anything happens to them, they are covered. No. When an issue of next of kin means that the person to be contacted once there's an emergency, if let's say the person has either an accident or something, just in case of emergency, ICE, that's what next of kin means. It has nothing to do with inheritance. Because even at the end of the day, when the person dies, the next of kin does not start to inherit. They'll just inform him that your relative or either husband or wife has died, though. Come. They will now tell him, okay, these are what was left. Now, it is now subject to the laws of administration of estate of that state. Or if the person had left a will, and if the person had left a will and has stated in the will
wow,
that these are the people that will inherit, and if the next of kin's name is not there, the next of kin will not inherit a dime. But the only time that the next of kin could inherit is if he's made a beneficiary under the will. That's when the next of kin will benefit from the so-called assets of that person or from the proceeds or the death benefits of that person. Now, many companies, organizations have been making that mistake, and it has resulted into a lot of lawsuits. That's why most of the organizations now that are up to date with the law, what they do is, even when they notify the next of kin, the next thing they will ask, is there a will? Was there a codicil? If not, what does the administration of estate law of that state states? We've had such instances that many of our corporate clients have had to ask us to wade into the matter and advise the company as to who will take the terminal benefits, the death benefits, of such a deceased employee. So the issue of next of kin that most people have been talking about, that they will put in their office, in their, maybe if they are filing for an application or something, it does not guarantee inheritance by the so-called named next of kin. The only time the next of kin can inherit is if such a person is made a beneficiary under the will, under the deed of gift, or any other such instrument. Thank you. Sorry, your mic is off again. Sorry.
I think I'm overexcited now. I was just warning. I said, my people, don't just think next of kin is the cocoa. No, it's not the real thing. Please, hey, my husband must. you know what I'm saying. These things are just well. Personally, I was just too naive over this issue. Everybody, I will go and start another awareness. Everybody must listen to this thing, because this is what we face so many times. Even as a family coach, you hear a lot of stories. You see many people coming to cry that they've been cheated. It's not that they've been cheated, it's because they didn't do what they should do. That's just it. Wow. Marriage in church does not mean you are legally married. We should find out whether the church has been what's the word you use now? Has been licensed. Yes, has been registered. You see, I'm using
now let me help you. For those people that don't know whether the church where they got married to is licensed, you know, the marriage certificate being issued by those churches or by the marriage registry carries the Marriage Act of Nigeria, Marriage Registry of Nigeria, and it's greenish. It has a green design on the paper. So it's different from all these so-called customized marriage certificates that we see around. It must be green in color, and it must have the heading either the Marriage Act of Nigeria. From there, they will be able to discern whether they actually got married under the Act, which is a licensed marriage recognized by the law. And if you just did a church wedding and the place of the church was not licensed, it is just a customary marriage that you went and celebrated in church. Thank you.
Wow. Wow. The time just doesn't want us to enjoy you more. I think we should have a family meeting. I should enjoy you better. Please don't go. Let me just conclude. Thank you for coming. Thank you for coming tonight. You have really blessed us. You have really blessed me. And you have blessed everyone that's listening to you, and everyone that will be listening again. It's a great time with you this evening, Barrister Rotimi Ajobiewe and Barrister Sheon Ajobiewe. We are really, really grateful. If we say we are grateful many times, 1,000 times, it's not even enough. Thank you. I know how much you would have collected if it's a personal or one-on-one thing. This is your work, but you have decided to bless us. Thank you so much. And we'll reach out to you on the other hand. Please don't go away. Woo, thank you for coming. Wow, my people, did you hear that? Love is sweet, love is sweet, love is sweet, love is sweet. Don't let love cover your eyes. Don't let love cover your thinking. Love with your heart and think with your head. You heard that? All this love, you forget about the necessary things to do. Let it not implicate our destiny. Enough of all these rivalries that we have among children. Enough of all these issues among siblings. Enough of enmity. Parents, please, let's do what is right. Let's do what is right. If our parents have done it wrong, let us start by doing what is right. I can't start all over again, but you know, ignorance is not an excuse in law. It is never. You do the right thing, you'll be rewarded or you'll be awarded what is due to you. But if you don't do it, if you are negligent, then you face the law. Thank you so much. Thank you so much for coming. I love everyone here. This is Family Robust. We do everything for us to enjoy our family. So I don't want to say bye-bye. Should I say it? Because next month again, we'll bring another wonderful edition of this webinar. You know, we are fully into this thing. I will keep bringing you a lot of things that will benefit you, as an individual, as a family, or whatever it is. And you could also suggest whatever you want to learn. Let me know. You can send me a DM. Let's know what you want so that we can give it to you. We are here for you. Thank you so much. I remain yours sincerely, faithfully, dearly, Janet Ajobiewe. God bless you. Thank you. Bye-bye.